I'm so excited to introduce to you our speaker for today. I would like to introduce our distinguished speaker today. Okay, so this Sir Wally, they called him, lives to share his knowledge to other people. And a talkative and hilarious guy, he started his teaching career the youngest in two big universities in northern Mindanao. He became a real estate broker, appraiser, and a lawyer during his 18th stint at a government corporation that was with real estate. He was credited as the legendary Rebap Cebu president Jose Pacquiao as the major contributor in the production of Rebap Cebu Top Notchers in August 2015 during the real estate appraisers exam, and 86% passing percentage rate of the February 2016 real estate brokers exam. Grabe, he helped so many people who become top notchers in the country. A national speaker, reviewer of various examinations, and a trial lawyer, topped by his associates on land cases and disputes. Mesdames et messieurs, ladies and gentlemen, please help me welcome Attorney Walfredo Lonsod Alcantara.
Thank you, Boston. It's always a privilege to lecture in Filipino homes, and thank you for having me. So
Yes.
I was really amazed. It's because before we prayed, there were only 299.
200,
But after that heal our land, it's already 400. So it is so amazing. Anyway, we will be talking about concepts of documentation and titling. When we talk about law is actually a very technical subject. And in this session, you will be taught what to craft, what to draft when it comes to contracts, which is very, very important. Although I believe many of you are salespersons, but it is very important that as a salesperson you would be able to know how to craft these contracts. And in the slides there are what you call a common contracts that could be crafted. Now here, why is it that you are also being encouraged to craft contracts? You know, if you know how to craft contracts and you present that contract to a notary public, you're bringing with you your client and also the other party for the purchase of land. You can ask the lawyer, if possible, that this would be the notarial fee for this document because it's already finished. So that's the beauty. And if, for example, your client will be the one who will pay the notarial fee, and the client would say, my budget for that is 20,000. Here's 20,000. So already have this finished contract being presented to the
Attorney, I want to cut you off. Is your mic, kasi I mean, we see a sound in your mic. Yeah.
I don't know. I could hear you.
Sound.
I could hear you here.
But now it's okay now. Yeah, it's okay now. Yeah.
Okay. So this is it. Concepts of documentation and titling. Okay. There is a difference between a document and documentation. That's the difference. So when we say a document, that is only a official or a legal document. Or if it's a computer file, it's a computer data file. If it is still considered as a document. But according to Cambridge Dictionary, so when we say documentation, of course, it is a noun, but uh, when we say document is a noun, documentation is still a noun, but there is, when you use that official or legal document, that becomes what you call the word documentation. So that's the difference between a document and and what you call documentation. So there is in documentation there is a second act. You have to use it for what? For evidence in court. So that is it. An official or legal documents that are needed in order to prove something. And the other one is an activity of recording facts relating to a particular subject. So there is a process that after you have secured this document, there is what you're going to do. Okay. Now, this is, so the first one is concept is you must have the ability to craft a legal document. Of course, it's in Google now. In fact, YouTube, you can always see everything in YouTube, from how to make a website to how to make a blog that can be found in YouTube. But the point is, do not rely on Google.com alone. So when you browse, when you search for a document, yes, you can have it in Google, but that's not how it is being done now. So then the second one is keep on reading. Keep on reading. There is no other substitute for that. It's, as a salesperson, it's not enough that you're a salesperson. So you have to improve yourself, and that is very important. That's why you're here, because law is technical, real estate is technical. So that's why you're here. Now, here you think of the requirements of the BIR and the administrative bodies. This is from the time you you craft the document up to the time of titling. In other words, if the property is still a tax declaration, so you think of the requirements there. You don't stop after the title was already transferred in favor of the buyer, or the name of the tax declaration was already transferred in favor of the buyer. Don't stop there. You can stop there if, for example, the property is titled. But if it is not titled, then that is, you have to think of the requirements of the administrative bodies or the courts. It's because you need to have another step, which is to have the lot titled. Okay, this is very important. Who will be responsible to pay for the taxes, transfer fees, and the legal fees? In other words, that statement must be stated in the, like, in the deed of sale, in the contract. I saw a document that omitted this one. The agent forgot to state this one. So this is a very, very important, because as a general rule, the one who is responsible to pay for the capital gains tax is the seller, because it is presumed that the seller gained in the course of the transaction. So this is very important. You have to state that one in the contract. Then secure a certified true copy of the title and of the latest tax declaration. Now, this is very, very important. That's why I told you it is very, very technical.
Attorney,
This is
Attorney,
not
excuse
like,
me.
yes,
Excuse me, attorney, because all of us,
Yes.
500 of us, there is a static on your microphone. I don't know what happened. Can you pull it out? And because when we hear you on our side. It is actually choppy and it will cut off. So I don't know
So
what happened.
am I going to get my
What about this one? Can you hear me?
Yeah, I can hear you with that. Yeah, that's good. Can you just
So I think I'm not
make
going
this?
to. I think I'm not
Yeah,
going to wear earphones anymore.
yeah, that's good. We'll try. We'll just continue.
Okay, okay. Thank you, Boston. Thank you. Um, make sure that it will be notarized by a notary public who is an active member of the Integrated Bar of the Philippines, and research also from the Supreme Court website on whether or not that lawyer or the notary public was suspended or it was not suspended. That is very important. To make the document public, it is, I advise you that do not have your document notarized only in, like, for example, it's at a law office. So you know, have it notarized to a competent notary public, a competent lawyer. Now, what is the effect here? If, for example, you have the document notarized by a person, by a lawyer who is a person who is not a lawyer, pretending to be a lawyer. And if, for example, what will happen to the document if, for example, the notary public was suspended at the time the document was notarized? Your property, your document will remain as a private document. So that is very, very important. Do not just have the document notarized because you can save money. So that is very, very important. You have to make a little research on the status of that notary public, whether or not he's suspended or is not suspended by the Supreme Court of the Philippines. Okay? So here, ask yourself this question: what document am I going to draft? So after you have talked to the seller of the property, for me as a notary public and also as a broker, you know, I always talk to both the parties. Some would not want to have the other party present during the negotiation. Why? Because probably there was a markup in the price of the selling price, which is, you know, which is not good for me, which is not good. The most important is you have a percentage in the when the property is being sold. That is very, so the concept here is, when you draft a document, the hint there is the simpler the better. So in other words, if you could have this document presented in one page, if it can be done in one page, that is better, because it is just like, you know, you're going to download an app, a software app in your computer or in your Apple iPod, and you just, because it's lengthy, you just agree on that, not knowing that you have already, you know, you have already agreed that they can use of your confidential information. That is very, very important. So the parties want to read a document that is simple. So my advice is, the simpler the better. Now, so you cannot sell a property without a authority to sell. Never, even if it's your friend, if it's your neighbor, if, for example, the neighbor will say, hey, don't worry, after the sale I'll just give you. Don't do that. You must be armed with an authority sell, if it is exclusive or non-exclusive. Now, I want to share this one. In RA 9646, it states that the salesperson is under the broker. In other words, the salesperson cannot just negotiate, cannot just deal without the consent of the broker. So in the authority in the authority to sell, the name that must be stated in the authority to sell is the name of your broker, because one broker is equivalent to 20 salespersons. Do not state in your authority to sell your name, because you are under, if something happens to that, so if it's in the name of the broker, and if something happens to that, then the broker is accountable for that. So that is very important. Authority to sell. So special power of attorney is very, very important when you go to the BIR, assessor's office, treasurer's office, or the register of deeds, and other administrative bodies. You must have a special power of attorney. And this is also very applicable if, for example, if the property is being mortgaged in the bank. So in other words, this is, although this is a standard practice of all the banks, that there must be a special power of attorney who can secure for the titles that are in possession of the bank. So waiver, affidavit of waiver, and affidavit of two disinterested persons. So a waiver, like this is very much particular if, for example, the father died and you are going to sign, you are going to craft a, extrajudicial settlement of estate, or, for example, a extrajudicial partition with waiver of rights. So that waiver of rights can be stated only in one sentence, that I am not interested in receiving any inheritance from my deceased father or mother. Now, when we say affidavit of two disinterested persons, this is very, very applicable when you have your lot titled. Like, for example, of course, before a property would be titled, it's a tax declaration first. Now, in a tax declaration, you're going to state there, you're going to study there, okay, the owner of the property. So the tax declaration and what you call in the DENR, the technical description, okay, must jibe the name of the tax declaration, and also in the, what you call this one, in the technical description, is that V-37 in the DENR must coincide. So in other words, if, for example, the name in the tax declaration is Pedro, but in the name of the technical description is Pedra, you will be needing this one, affidavit of two disinterested persons, which is one of that is the barangay captain of that locality. And you can say in the affidavit that Pedra and Pedro are one and the same person. So that would be admitted by the DNR when you have that one titled. So deed of conditional sale, you know what a contract to sell is. So when a contract to sell is different from the deed of sale, there is no transfer of ownership. And in the deed of sale, there is a transfer of ownership. Now, in the deed of sale, sometimes, like for example, the couple would be leaving the Philippines because they have decided to leave the Philippines and go abroad. So the fixtures, the appliances, the furniture will be included in the sale. In other words, my point there is you have to list this appliances, the name of the appliances, the furniture. If you can have it, like for example, a picture of this that's very good. That is being attached as Annex A in your deed of sale. Now, especially if your client is a foreigner who wants to buy a condominium in a Cebu, like for example, and it includes everything, they want that one stated in the that one is stated or attached the lease must be attached in the deed of sale. Okay, so extrajudicial partition, extrajudicial settlement of estate. So after, like for example, if the property is for sale, and usually the father, although there is already a research on that, but usually between a husband and the wife, who dies first is usually the husband. So in other words, if for example you prepare an extrajudicial partition of sale, okay, extrajudicial partition of sale, extrajudicial partition with sale, if for example. So it is not advisable that if for example the father died, you're going to sell the property already. That is, or you craft a deed of sale. No, the buyer will be placed at a disadvantage because the sellers or the heirs must first pay the estate tax. So in other words, if before the sale, you can have it extrajudicial partition first, or extrajudicial settlement of estate, or if you want to sell it, extrajudicial partition with sale, or extrajudicial partition, extrajudicial settlement of estate with sale. That is the proper thing to do, even if it's directly for sale. Now, so in extrajudicial partition, you have to make a family tree, okay? A family tree, and you know, when I discuss about you know, how to be a successful salesperson or a broker, one here is that do not procrastinate. So if you can do it now, do it now. So that's it. So in extrajudicial partition, all you have to do is to make a family tree. Family tree. So when you make a family tree, if there are 5 of them and one already died, many of the salespersons, when they craft documents, they will just let one of the children represent the deceased father or the deceased mother. That's what they usually do. No, that is, if for example there are 5 and one died, so you are going to include the surviving spouse, if your mother is still alive, your mother, and the 5 children. Now, the 5 children, if one already died, you get the name of the heirs. You get the name of the heirs of that uncle or son or daughter who died. All must sign. Now, listen to this. You will have a big problem if you're not going to include, like for example, usually in my practice, they don't want to include the illegitimate child. So they just sign the one without the that is very fatal, because when the property is being sold, the person who was not included, who did not sign in the extrajudicial partition, will file a case against the half siblings, the surviving spouse, and much worse, including the buyer, so it's really a big problem. Okay, so here, deed of donation, whether absolute or conditional, the most important is there was knowledge on the part of the donor that the property was donated, and it must be notarized. Okay, lease with option to purchase and lease purchase agreement are 2 distinct contracts. So when we say lease with option to purchase, okay, I lease the property for 6 months, but I have the option. It's up for me if I am going to purchase it after 6 months. In lease purchase agreement, you are obliged that after 6 months, you are going to purchase that property. Now, usually, because Filipinos, there are only few who can afford to buy, units in cash. So what they usually do is a deed of sale with the assumption of mortgage. And if the property is being mortgaged with a bank, always remember this, in the bank, they don't recognize that one. Even if you have a deed of sale, and usually when the salespersons or brokers do this one, deed of sale with assumption of mortgage, and that would be notarized, and there is a deed of sale that is not notarized, that will be notarized only after the full payment has been made. So always remember that if you are going to assume a property in a subdivision, for example, and it is, even if it's not a subdivision, but if it is mortgaged in the bank does not recognize your agreements. In the bank will recognize only the original person who loaned money from the bank. So that is it. And that is why you were taught how to you were taught that you can craft a deed of sale. You can, like for example, you can make a special power of attorney, because once it is fully paid, you are going to present the special power of attorney from the original owner, that you can already secure the titles from the bank. That is the usual practice in all banks in the Philippines. Okay, so deed of undertaking is when you say deed of undertaking, this is what we're going to do. First party, second party, obligations of the first party, obligations of the second party. That is deed of undertaking. Now, there is a difference between a memorandum of agreement, MOA, and memorandum of understanding. When we say a memorandum of understanding, it is a sort of a gentleman's agreement. In other words, it is just like a letter of intent, which cannot be legally enforced if being violated. You cannot go to the courts. So if you want to have this, if you want to have the parties legally obliged, you craft a memorandum on agreement. Okay. So when you go to the BIR, always remember, ladies and gentlemen, that in my experience, there are only two government agencies that you need a lot of patience. One is BRR, and number two is LTO. So you need a lot of patience there. So check the requirements of the BIR for payment of capital gains tax and documentary stamp tax. Although it states that as a rule, the capital gains tax is being paid by the seller, because gains were presumed. That's it. Now, this can be agreed that it's the buyer who will pay for the capital gains tax. But in the documentary stamp tax, it is the buyer who pays for the documentary stamp tax. It is because it is the buyer who wants to have the title transferred in his name, or the tax declaration to be transferred in his name. So, and deadlines for paying taxes, when it comes, is usually 30 days from the conclusion of the contract. When it comes to capital gains tax and documentary stamp tax, is 5 days after the close of the month. But now, because we have this COVID problem, the BIR, through the Department of Finance, issued Revenue Regulation 11/2020 that states that the payment of these taxes would be 30 days from the lifting of this quarantine. So if, for example, on May 15, this would be lifted, then the deadline would be on June. It would be June 15. It's 30 days from the lifting of that quarantine. Now, actually, there are, if you take a look at the if you take a look at the re- requirements in the BIR, there are actually 9, but in 9 requirements, actually, that includes already corporations and partnerships. So basic, the most basic here are the following. So when you craft your deed of sale, in the deed of sale, you use the TIN of the parties. Because when you go to the BIR, they will check whether or not the TIN is active. So that would be the competent evidence of identity, the TIN. Okay, you need the latest tax declaration because the role there is how much the taxes would be paid. Then the deed of sale, deed of transfer, certified true copy of the title, and also in the latest tax declaration also, they would also ask if there is, in case of cities, like for example, the parking lot is being, like in condominiums, the parking lot is being sold to other party. So they will also ask for a tax declaration on that. So, okay. So deed of sale, certified true copy of the title. And if the property is bare, you need certificate of no improvement. After this, now, in my experience, sometimes it would depend on the revenue, district office. Now, they require that an evidence of receipt of the money needed by the BIR. Sometimes they also ask for the receipt of the notary public, which is not actually the mandatory requirement. Probably they just want to monitor if this lawyer, if this notary public is paying his or her taxes. So if it is, if for example you are covered with a special power of attorney, it's a special power of attorney there. If it's a corporation, there's a secretary certificate. So I hope you got that one. Okay. Now, in the local treasurer's office, you can get a clearance there, but in order to have it transferred, they need the e-car from the BIR. So documents needed there: photocopy of tax deck, land improvement, building, condominium, parking lot if applicable. Then original copy and 1 photocopy of deed of sale, and official receipt of the payment of real property tax and special education fund for the current year. Now, when you go to the register of deeds for issuance of a new title or condominium certificate of title, you need these documents. Okay, so original copy, 3 copies, duplicate copy, original copy of e-car, original copy of tax deck, original copies of official receipts, payments of DST, AGT. Okay, may I inform you that because this is now the new normal, payment can now be done with a BIR through GCash. Okay, so that's it. Then, original copies of the current tax declaration for land and improvement issued by the local assessor's office. If the seller or the buyer is a corporation, submit the following documents. Okay, secretary certificate, certified copy of the articles of incorporation. Now, after that, when you have done these things before the registry of deeds, you have to go back to the assessor's office, the local assessor's office, because you need also to change the name in the tax declaration. And these are the photocopies that they need. And in additional documents, if usually in series, so they ask for subdivision plan, if lot is subdivided, and for full color photos of the house, lot, and condominium unit. Okay. Now, in administrative agencies, when you have your lot titled from the tax declaration, okay, you may go to the DNR or Department of Agrarian Reform or NICP. What is NICP? That is National Indigenous Commission of the Philippines. Okay, so the most important here, when you have the lot title, there is what you call connection of documents. So if, for example, in the tax declaration and also in what I told you about the technical description, the names do not match, you need that what I call you as two disinterested persons. Okay, that Pedro and Pedro are one and the same person. So you can now have a connection of documents. Connection of documents from Pedro. So the technical description is considered now as Pedro. So the tax declaration is Pedro. And in the deed of sale, it was Pedro who sold the property to the buyer. So always remember, connection of documents. Okay. Now we go to titling. Now in titling, why is it that here, if you could remember the here connection of documents, it is because, why is it that courts are included there? Because in titling, you only have two choices in titling. It's either you hire a lawyer to have your lot titled, or you go to administrative bodies. Okay? So if you want to have to go to administrative bodies, you go to DNR. If the usual titles of lands are residential patent, free patent, and also homestead patent. Now, always remember here that public lands are classified into two, A and D. So in other words, when you have that one lot title, when you have your lot titled, it is important that the certification of the DENR or the status of lot, that the lot is alienable and disposable. If the lot, that is the requirement. It must be alienable and disposable. So if you take a look at this one, alienable and disposable can be classified into two: agricultural lands and non-agricultural lands. Now, you can also go to DAR. If you want to have your agricultural lot title, you can also go to DAR, Department of Agrarian Reform. Now, the problem is this: there is no more notice of coverage after the extension of the DAR. You have to take note. Probably you have encountered a title that is known as emancipation patent. This emancipation patent is based on Presidential Decree number 27 during the time of Marcos. It states in the title that this land cannot be sold or cannot be transferred except through hereditary succession or sale to the government. Now, if you would be able to encounter a lot, like for example, can you sell this property to me? Can you sell this property? This PD20. This is emancipation patent title. The first thing that you're going to do is you go to DAR to ask for clearance. Do not craft a document, the deed of sale. You need a clearance from the DAR. So there are non-alienable that can be found in the Constitution: timberland, forest, mineral lands, and national parks. So NICP, that's it. It talks about natives, ancestral domain, NICP. So you get it? It's mentioned here. Modes of acquiring title. It's either administrative way or judicial way. Then you go to you get a lawyer if you resort to judicial proceeding. Now, always remember here. Always remember. In administrative titling, this is, for me, also a big source of revenues on your part as a salesperson or a broker. as long as you have what you call a special power of attorney. Usually, when I have the lot titled from tax declaration to titling that with the title already, I usually ask 10,000. But actually, to be honest, in administrative proceedings, it is very cheap. You will be given only you will be given then if I'm not mistaken, you only pay 150. But the problem is the work to be done that you have to follow up. So in my case, although that's 10,000 that I asked from a particular person, from the person who wants to have this one titled in his name, but I am honest to tell that you can have this one titled in your name. Just follow the procedure. That is, but sometimes they will say, attorney, I'll just pay. Okay, then that's it. That is a source of an income, revenues for you. Okay, so modes of acquiring public lands: free patent, homestead, sales, lease, judicial confirmation of imperfect title, special patent, and residential free patent. So these are laws under Public Land Act and also RA 123. Now, always remember, if you have a title, it does not mean, always remember this, if you have a title, it does not mean that you are the owner, you are the absolute owner of the property. Probably you are asking, if you have a title in your name, it does not mean that you are the owner of the property. Like, for example, if, for example, there are two of you, your parents already died, there are two of you, one of you went, your sibling went to America. So you executed an affidavit of sole heir and submitted before the Registry of Deeds that you are the sole owner of the property. Because of your representation, the property, the title was titled in your name. But the question is, does it mean you are the owner of the property? Now, there was fraud, which is also a ground for the cancellation of your title. Now, always remember that you are only a trustee. You own only 50% of that property. That's why many siblings file cases because of this. All I can tell you is attitude is altitude. So attitude is very, very important. Patience is very, very important. So if you have already possessed the property in free patent for 30 years, it is actually yours. The title that was issued by the DNR was actually a confirmation, an affirmation that you own the property. Okay, so adverse possession, OSEN, open, exclusive, continuous, notorious, but it does not apply. So in other words, in land titling also, even if, for example, the property has only a tax declaration, if the person who encroached the property possessed the property for 30 years, whether in good faith or in bad faith, then you have a problem. The property may now go to the intruder. Okay, so the deadline for free patent will be December 31, 2020. Then this is the process flow. So all you have to do is, if you want to have the lot title, you go to Senro, Penro, then red is Regional Executive Director, then Secretary, ROD, applicant. So all you have to do is to study the one. Now in homestead, it requires 20% of cultivation, and he must reside continuously for at least 1 year in the municipality where. Okay, this is also the process flow of homestead application. So all you have to do is to follow this one, because I told you already that this is this is a source of income. Okay, So if you take a look at this, these are the distinctions between the free patent and the homestead patent. So, okay, all you have to do is reading when it comes to sales patent. All you have to do is read, because usually when we usually deal with residential patent, we deal with homestead patent, we deal with free patent. So when we say sales patent, then you have to buy it. That's it, sales patent. And these are the requirements, checklist in the preparation issuance of the sales patent, then process. That's it. The procedure. Okay. All right. Sales patent. Sales application, miscellaneous sales application, steps in miscellaneous sales application. That's it. All you have to do is to read it, check the procedure. Okay, sales patent. If 1,000 square meters and below, it needs direct sale. If more than 1,000 meters, it is through public bidding. So these are the requirements of miscellaneous sales application for residential purposes. These are the checklist. This is the process flow. If you want to have a sales patent, miscellaneous sales patent, or MSA, town site, a special patent, like for example, properties of the government. This is a special patent. Steps in processing the special patent. Signed, the special patent signed by the president or the DNR secretary when authorized by the law or proclamation. Okay. Now, this is a residential free patent. I wanted to avail this one if, for example, you want to have the lot title, because actually if all the documents are already in place, already submitted with the DNR is given only 120 days to have a title produced. So in other words, it's fast. And in residential free patent, actually, if before there was a need that you need to wait for 5 years before it would be sold, in residential free patent, that is not, that there is no limitation now. That is not a restriction. Once it is issued, you can already sell it. That is residential free patent. So that is the law, RA 10023. This is the coverage of the residential free patent. You can read it. Untitled residential lots, town site areas, the listed and abandoned military camps, schools, public plazas, halls, and other government institutions. Okay, so here the requirement is only a Filipino citizen. So a Filipino citizen may be a natural born citizen or naturalized. Yeah, he applied for naturalization. So naturalization is Congress. A Filipino citizen and naturalization. Okay. Then patent subject to constitutional limits on total lands acquired 12 hectares. That is stated in the Constitution. Now, if the lot is in a highly urbanized city, it must not exceed 200 square meters. In other cities, 500 square meters. First to second class municipalities, it is 750 square meters. In all other municipalities, like third class, fourth class, fifth class, it's 1,000, more than 1,000 square meters. Okay, this is the documentary requirements. Okay, affidavit of two disinterested persons confirming 10 years occupancy on that on the locality. This is where I told you about affidavit of two disinterested persons, that Pedro and Pedro are one and the same person. Okay. Applications will be supported by a map based on actual survey by licensed genetic engineer approved by the DNR. Map should contain both technical and physical description, zone residential area by LGU. These are the documents, the checklist that you need to have the lot titled, and the processing is 120 days. Okay? After all the documents have been submitted, then forward to Penro, Provincial Environment Natural Resources, and the Penro must act within 5 days. So it can already be sold once it would be issued in your favor. Now, listen to this. Before, under Commonwealth Act 141, you need to wait for 5 years before it would be sold in free patents. But in accordance with Republic Act 11231, there is no restriction now. And this restriction, this lifting of restriction, is given retroactive effect. And this was signed by President Duterte. Okay? It became effective in March of 2019. Okay. Restrictions of special patents cannot be disposed, sold, or leased without the authority of Congress. Or if national government agency or the Sanggunian through an ordinance, if LGU property. Look at the process flow. This is basic. Once you have this accomplished, this is form, you pay, submit the documentary requirements, then you go to Senro. Then you go to Senro, you go to Penro. Then if it needs the approval of the Secretary of Environment and Natural Resources, you go to Secretary, but it would end up in the registry of deeds, and the property will be, the title will be given to you. Now, you have a minor problem here. Like, for example, if, for example, the property was inherited, you cannot get your title if, for example, the estate tax was not paid. So that's very important. They will not enter the title in their computer if, for example, the estate tax was not paid. Okay, take a look at this this presentation, the slide, no? Application. In application, copy of the DNR approved plan, copy of the technical description, simplified research, affidavit of two disinterested persons, certification of no pending land registration proceeding from RTC. That's what you are going to complete the documents. Then you go to Senro. Then you have it there. You have it there. What are needed? So you have application form, A and D certification, or you have the alienable disposable certification from LGU that the land is not needed for public use, zoning ordinance, the posting of the certificate of post, okay, posting and certificate of posting, investigation or ocular inspection, order issuance of patent, transmittal to Penro. So you could see the process flow, okay? Then you go to Penro, review and approval of patent, transmittal to the Register of Deeds, then your Register of Deeds, registration of patent, and distribution to the title owner. Again, you need here, if you're the salesperson who processes that one, you need the special power of attorney here. So take a look at this. In DNR, that's why it is simplified, because they already have this survey and mapping. Take a look at this one. Okay, take a look at this one. Then in DNR, DAR, NICP, or Regional Trial Court, or LRA. What you need, take a look at titles issued, homestead patent, free patents, miscellaneous sales, special patent, CLOA, that's Certificate of Land Ownership Award. EP is Emancipation Patent. In Certificate of Land Ownership Award, you are given 10 years. So there is a limit restriction that you cannot sell the property within a period of 10 years. When we say judicial decree, in other words, this is the what I told you about judicial mode of having your lot titled. But of course, it is very expensive if you get a lawyer and have that one titled through judicial proceedings. CADTI and CALTI. What is CADTI and CALTI? CADTI is Certificate of Ancestral Domain Title. So this is being issued by NICP, National Indigenous Commission of the Philippines, and also CALT, the Certificate of Ancestral Land Title. Now, the first title that would be released is called Original Certificate. The succeeding, so that is original registration here. Then the succeeding, we call it Transfer Certificate of Title. Okay. Now, I want to encourage you, salespersons and brokers, that it is not enough that you just buy, sell the property. You must be able to craft documents and read. Keep on reading and reading. As what Steve Jobs said in one of his speeches, where I think that was Stanford University. Stay hungry and stay foolish. Do not be content of what you have now. Thank you very much. I hope you learned a lot. Thank you, Boston.
Wow. So it is a very interesting topic. I mean, a lot of people here are having a lot of questions, and they throw so many questions here. So there's a question: what are the basic documents that a real estate agent should learn to craft in relation to facilitating sale and titling?
The concept in that, if you could remember that one, number 1, 2, 3, 4, 5, 6. So the sixth one there is administrative bodies. The technique there is you start from number 6. You start, do not start from number 1. You start from number 6, so that when all these documents are already in place, then it's easy to hand over these documents to government agencies.
So that's interesting, huh?
Yes.
So, okay, there's some questions here. We still have about 10 minutes. So, number 1 question is, what if the legitimate child is not recognized by the family? Can he still claim his part?
Yes, that is, it is very important that if there is that is what you call preteration. So, you did not include one. So, in other words, you have the person who was not included must file a case against the siblings.
Okay.
Yes, that's the way how to do things.
Yeah. So, next is, can timberlands be sold?
No. Under the Constitution, I told you already, these are what you call non-disposable. In other words, like mineral lands, it cannot be done. In other words, if you want to purchase that one, you are purchasing only the rights. It can still be done, okay? But do not assume that it can be titled unless it would be released by the Congress that it's already A&D, or it will be released by a presidential proclamation that it is already alienable or disposable. But if it is not, then what you are buying is only the rights.
Okay. So it's right. So rights cannot be titled, correct?
Yes.
So another question, attorney. I know someone that have a problem with the lot. Family A sold a residence lot to Family B. Family A paid in full but did not process the titling of the lot. They just have a deed of sale and acknowledgement receipt of the payment. Unfortunately, both parents of Family A and Family B are both dead. Now, the children of the original owner of the lot wants to get back the lot. What's your opinion?
Okay. That is what I told you. Do
That's
not
common question. No?
Yes, do not. That's what I told you. Do not procrastinate. Anyway, that's all. That is already the problem. Anyway, once there was already a sale of the property by the parents. In other words, because there was a sale of the property by their parents, the property can no longer be recovered. So, but it is very risky if you don't want to have the lot titled. I transfer it. If you don't want to have the lot transferred in your name, it is because it could be sold to another person, and the other person
next day, yeah.
would say, it was in good faith that I sold the property, so, that I bought the property. So that is very important.
Yeah. So the lesson here is once you buy a property, transfer it right away. Correct?
Yes.
Yeah. So what if an old maiden who owns a lot died and one of her nephew processed the transfer title to her name, stating it was deed of donation?
Okay. Well, if there would be claimants, you have to file a case.
Yeah, file a case.
In court. It is because you have to prove forgery like that. So you cannot just say, "Oh, that was forged." You have to prove it. The person who alleges must prove that one in court.
Correct. So another question: can a private lot for sale be sold without a broker's intervention? Just the owner of the land and the unregistered salesperson.
What?
So there is a question. A private lot owner. So he called an unlicensed salesperson and no broker. Can they pursue with the sale of the property?
Okay. Actually, it can still be done, but
Mhm.
there are repercussions. There are penalties, but it can still be done.
Okay. So, but it's very risky because the moment there will be some people see you that you're not protected by a broker, then you will be colorum. So you have to be protected, right, attorney?
Yes.
So another question here is how do we deal with CAD classification land, CADT?
Okay, CIDT is that is NCIP jurisdiction already. So in other words, that is Certificate of Ancestral Land Domain. These lands are vast lands. It would be more than hundreds of hectares. In fact, some are thousands of hectares, because we believe that the natives were the original settlers here in the Philippines, and we believe that we have to we have to respect and also to protect their culture, and that's why the NCIP will process also the titling of this land. Now, in the deed of sale, this is not a case of like for example you sell the property to a educated person, because these natives are not educated. So when the property is being sold, as a general rule, you can only sell the rights. You cannot sell the property. Only the rights. So in other words, if there's a native who would approach you, you only have the rights. There's a possibility that the native would approach a lawyer and recover the property. So be careful in dealing with ancestral domain titles.
How about the prior lands? Prior lands.
Okay, so these are lands already granted to, granted during the time of the Spanish era, and they were also recognized here in they're recognized here in the Philippines.
How? What about the protection of a person who bought a piece of land from Katutubo? The property is a timberland, and he fully paid the Katutubo already. What are the documentation of that person needed to legalize the transaction?
Okay, it is necessary that they have this datos. They have the head of the tribe. So in other words, what they usually do is all these heads of the tribes or the datos are present in the sale of the property. That's what they usually do.
How does the government intercept Apolorum people? Very easy. The only way, we Filipino homes, okay, my advice to all of you, don't be a Apolorum. When you deal a property, call a broker, call your team leader, we will protect you. Attorney Wally is here, he will protect us. It's very important. You have to go with the process because RESA law is already a law. Okay, so in order to sell a property, you have to be protected. Correct, attorney?
Yes, yes.
So pwede ba ibenta ang land na declaration lang?
Yes.
And docs will be late.
Okay. Yes, but
declaration land, can we sell it? Yes, di ba? You can sell it, but you don't have the full right. Yes, yeah. Attorney?
Yes, because it's when you reclaim, it needs the approval of the reclamation authority.
Okay.
It's not like titling for free patent or homestead patent. It's not like that. So you need the approval of the reclamation authority in Manila.
So a lot awarded to Boy Scout of the Philippines to the father's name. This is allowed to sell sister of the father?
Well, actually, we talked about trustee. So the father is only a trustee in the title. His name is there. That's what I told you. I mentioned a while ago that it does not mean that if your name is in the title, you are the owner of the title. So
Correct.
You may be a trustee. So the father is only a trustee of that. Because it's only a trustee, considering also the Boy Scout of the Philippines is a non-profit organization, it's not, you cannot sell, the sister cannot sell it, of course.
Yeah. You're just entitled to hold it.
Yeah.
What if the surviving spouse sold a lot with the legal children and after a year an illegitimate child claimed his share? How does it work?
Okay. That is, in the law, once there is somebody died, or the owner of the property died, you need that extrajudicial partition. That extrajudicial partition, it states that in section 4 of Rule 74 of the Rules of Court, it must be annotated there at the back of the title. It annotated that within a period of 2 years.
2 years, yeah.
It is subject to claims by creditors and by heirs. So in other words, because you mentioned a while, if it's only 1 year, so he can still claim it. In fact, there are many cases. Even it's more than 2 years. But
they still have a case, right?
Yes, they can still have it, and that is a risk on the part of the buyer because there was a misrepresentation on the part of the seller.
Yeah. So is it possible for a sales agent to process an extrajudicial settlement to a state family?
Yes, it is possible, but
ang agent, yeah.
Yes, it is possible, but
You have to be authorized, right?
yes, authorized, and also once it would be notarized, it would be in front of the notary public.
Ito, common talaga to. So, a seller, with an agent, other person. Now, here's another agent, from Filipino Home dealing with it. So, what if you're going to buy a property handled by an unlicensed agent? So, merong property na ang nag-deal, unlicensed agent from the other, from the side of the seller ba? How do we deal with the negotiation?
It is necessary that an accreditation should be asked first from the person, from the one who is
Person.
pretending to be a
From the unlicensed. So, how's he presenting? Will he say na, okay, you're dealing with this property, can be your license? Like that?
something's wrong with your microphone, Sir Ton. I cannot hear you. It's choppy
Yeah.
already. I don't know what's wrong.
Yeah. So, like this. Can you hear me?
Okay,
Okay.
you try it
One,
now.
two.
Okay, I can hear you now.
Yeah. Is it okay? Yeah. So,
Okay.
question is, how do you approach if you are dealing a property with an unlicensed agent from another party? So you'll ask, you ask a certificate or what?
An accreditation from the board. Okay, so these salespersons, they need to attend seminars. Okay, and they need to go to the PRC on that. So that is, they have to be accredited, and that document must be presented if that would be asked during the negotiation.
Yeah. So my advice to all Filipino Homes agent, if you encounter another property who is handled by an unlicensed agent, don't deal with it if they are not professional. You know, the question, Manggod, is most of the agent, they look for another property and there's another property handled by another agent. You better go to a property direct to you. So find a seller direct to you. Don't find a property that is handled by unlicensed agent. You are just accommodating unlicensed agent in your business. So the secret of Filipino Homes is go to a property who is the owner right away, direct. Okay, so that's the secret. Okay, so you don't have problems that you can face in the future. So I have a lot, but it is on deed of sale, but the owner is already dead. How can I process the lot to have it titled?
Okay, so because there was procrastination on your part, so in other words, there is a need to have a deed of extrajudicial settlement with sale in your favor. Because, like for example, if the property was sold in 1990, and the original owner died in 2020, so there is a need for a extrajudicial settlement and sale, and that is a big problem on the part of the buyer, because the buyer will now pay for the estate taxes, and also that's a big problem. So that's what I mentioned a while ago. Do not procrastinate.
Yeah, and yeah. Attorney, we have this case. The ancestors of my parents died already, and their lands are not yet titled, divided to their heirs. What is the best thing to do?
Okay, you make a family tree. So you make a family tree. You sign once you have the family tree now, if there are 5 children who died in the 5 children, then you make another family tree for that person who died, and all those persons should sign. So it is it is an extrajudicial partition with a special power of attorney, because it is easier to dispose the property if only one will sign in the deed of sale. So the title of the document will be extrajudicial partition. After you have this family tree, let them sign, all of them, and only one will sign for the deed of sale. That's why extrajudicial partition with special power of attorney.
So land is only under tax debt. There are 5 heirs. One of the heirs built a house on a certain portion of the land, but he is paying for the land tax of the whole land. So is it true, attorney, that he can already apply for titling if you are paying for the tax of the land, property tax, for more than 10 years? Is it
No.
true?
Actually, tax payment, tax
Tax
receipts
debt.
are not conclusive evidence of ownership. Now, if, for example, that person would have the lot titled in his name, again, he's only a trustee. He owns only a portion of that. So if there are 5 of them, he owns only 20% or 1/5 of that. So that is it. But it's not true that if you're the one paying the one, it's not true.
Example, I buy a property tax debt, then after 25 years, nobody, I want to title it. I paid for 25 years for the tax debt. What's the precautions of the attorney?
Is still the same. If that would be titled, the one who had it titled will only be a trustee of the other siblings. Why? Why? It is necessary in co-ownership, because there was co-ownership. There was co-ownership of the 5 siblings. Co-ownership. So if there's co-ownership and the title was in the name of one co-owner, he's only a trustee of the other co-owners. Now, if, for example, he wants to have the title in his name and he doesn't want to share it with other siblings, the remedy there is to perform acts, to perform acts that there is no more co-ownership. Like, for example, he had the lot fenced, all of this lot fenced, and he placed it there. No trespassing, even siblings not allowed to trespass. That is an evidence that you repudiated the co-ownership. So if it is repudiated, there was already repudiation, then if the lot would be titled in your name, then the lot cannot be recovered anymore from you.
So, Attorney Wally, thank you very much for having us here. We are so honored and we're happy with all your expertise. Okay, so thank you. And to all Filipino homes, we'll be back with Attorney Wally. So we can have question and answers for 1.5 hours. So do you like that one? So we'll have him back in the future. So thank you.